The first part is the human part. Some cults have become famous or infamous for taking intimidating actions against lawyers who oppose them, and also ultimately for buying lawyers off with huge settlements from which the lawyers made great sums of money. I personally never experienced that except on one occasion, although my colleagues have, and one of them has experienced it as recently as a few months ago. He is still litigating against this particular group on behalf of a particular client. One of the members of this group was a few months ago was staring in the window of his house at his wife, which is, you know, very unsettling to a woman with a couple of children there and so on and so forth. Unreal, one might say. So this group apparently is still continuing on doing some of the things that it has done. The only thing they ever did with regard to me was we had a federal court of appeals hearing once, and those hearings are normally attended by as many as 2 or 3 people. You know, the audience is usually sparse, would be a way to put it. And this group loaded the courtroom with people, and they were maybe there's not a nice thing to say, but it was like the great unwashed staring at you, and in many cases, obviously, they were. And afterwards, as people walked out, hordes of these people, scores, hundreds of them, including ones who couldn't fit in the courtroom, would just stare at you, you know? Mm-hmm. And it was very unsettling to my wife. Having been unconventional most of my life, this stuff rolls off of my back like a duck, water off a duck's back. But this was very unsettling to my wife. So, from the human standpoint, not too much of a problem. From the professional standpoint, it was an absolute stone wall. They were employing some of the nation's major, it's a small firm, but they are among the nation's major civil rights lawyers. They have, I'll put it bluntly, sold out for hundreds of thousands of dollars. They would produce nothing. The cult members, some of them were lawyers, and they'd sit in. They would give you no books, none of the things that a lawyer is supposed to do in discovery would they give you. They'd always argue their religion and not susceptible, therefore, to anything that's going on in court. They would not, it was almost impossible to, depose witnesses. And they were prepared, because they're very wealthy, they were prepared to, and did, spend any sum of money necessary to outlast, outfight, outdo, outstubborn, out-obstinate the opponent. What was right or wrong had absolutely nothing to do with it. And I must say that to a rather considerable extent, the courts, and you know, you're well aware that the misdeeds of the federal courts are one of my, I shouldn't say favorite topics. They're a topic on which I am almost obsessed, one might say.
Not you, Larry.
Not me. No, I wouldn't be obsessed about anything. If I were, I'd be a cult member, right? I've got my own cult. The federal courts let them get away with this to an extent that never should have occurred, because the federal courts are very, very leery of treading on what is at least alleged to be religion, right, to the point where they will not even, or they are loath even to take action against actions that are antisocial actions as opposed to beliefs which are protected by the religion clauses.
This excerpt is brought to you by the Massachusetts School of Law, the leader of reform in legal education and a leader in multimedia education for the public. To view the full interview and for a full listing of MSL's programs, log on to mslaw.edu.